Great.
Good. Go ahead.
Good afternoon, everyone. We're here to talk about summary judgment, everyone's favorite subject. The goal of this program is to try to have you understand what summary judgment is, which is actually a loaded concept. I've done this program 3 or 4 times now, and each time I go through the slides, I learn something new about summary judgment that I hadn't really realized before. So we'll get started here. The second thing that we're going to be, that I want you to understand is to know the essential components or parts of what a summary judgment motion is. So this hopefully will just be the tip of the iceberg. What is a summary judgment motion? Well, first, what is a motion? It's just simply a request that the court do something that you want the court to do. And in terms of summary judgment, it's a request that the court dismiss all or part of your opponent's case. It's a procedural mechanism, which means that in the course of a lawsuit, you are allowed to ask the court at a certain time to dismiss all or part of the opponent's case. The authority for summary judgment in state court, at least in Wisconsin, is found in the Wisconsin statutes, and in federal court, it's found in the Federal Rules of Civil Procedure. Both plaintiffs and defendants can use summary judgment, and it's only available in civil cases. It's not something that's used in criminal cases. So before we get into summary judgment, I want to back up to go to the essential components of a lawsuit so you understand where summary judgment fits in. First, we have the complaint and the answer, which tell us what's the lawsuit about, who is complaining about what, and why do they think it was unlawful. The answer, the discovery, where you learn about the other side's case, and after discovery, there's summary judgment. If the case proceeds past summary judgment, you have a phase of trial preparation and then finally a trial. To really understand summary judgment, I think it's important to understand what happens at trial. So we're going to jump ahead a little bit. At trial, the fact finder, which is a jury or a judge, hears evidence. The jury is instructed on the law. If it's a bench trial where a judge is hearing the case, the judge is instructed on the law, usually in a brief that the lawyer submits to the court before or right after the evidence. The fact finder determines what happens and then applies those found facts, the facts that they find, to the law and decides who wins. So that's the fact finder's job. To hear disputes of fact, and we're going to talk about that word dispute. That's an important word for summary judgment. Weigh conflicting evidence, and when we say weigh, we mean decide who is credible and who is not credible. And then decide what happened. If there is no dispute of fact that matters to the outcome of the case, then there is nothing for the jury to do, and a trial is pointless. And that's where summary judgment comes in. So, why do we use summary judgment? To win a case and avoid trial. We want to try to stop the lawsuit in its tracks before it goes to the very time-consuming and expensive phase of pretrial and trial. Another reason we use summary judgment is to narrow a case before trial. So we might be able to get certain claims dismissed or certain defendants dismissed. Or if you're a plaintiff and you file for summary judgment, you may file for summary judgment on a claim and say, well, judge, based on the evidence that we have here, there's no way that the defendant can win. That claim might be decided, and then the claims are narrowed for trial. So the purpose of summary judgment in civil litigation basically is to do less work and save money. Those are things that everybody can understand. The summary judgment standard. Why should a court grant summary judgment? The buzzwords are when there is no genuine issue of material fact and the moving party is entitled to judgment as a matter of law. I think that is probably one of the most loaded sentences that has ever been written about civil litigation. It seems so simple, but it's not. The moving party is the party that files the motion for summary judgment, so that's important to know. What is a genuine issue? A genuine issue is a disagreement about the facts of the case, a disagreement about what happened, but it must be a real disagreement. And I'm going to give you some examples. What is a genuine issue? An example, witness 1 says, I know Steve well. I saw Steve shoot Mary. Witness 2 for the other side gets up on the witness stand and says, I know Steve well. I saw someone shoot Mary, and it definitely was not Steve. So if that's your case and you have a situation where two witnesses for different sides are saying completely different things, you have a dispute of fact. There is something for the jury to do. Another example would be, say, in a medical malpractice case. Witness 1 says, I was assisting Dr. Rogers perform the surgery. He was coughing and sneezing throughout, was sweating, and he looked like he was quite sick. Dr. Rogers goes and he testifies for himself and says, I was feeling excellent the day of the surgery. I recall clearing my throat only a few times. So again, the jury's going to have to decide who's telling the truth. That's a genuine issue. It's a real disagreement about what happened. But some disputes are not genuine issues because a jury would not reasonably believe one side of the story. Here's an example. Witness 1, I know Steve well. I saw Steve shoot Mary. Witness 2 gets up and says, I never met Steve, but my friends tell me he has a weird-looking beard and big feet. I just left the bar. It was 2 a.m. and very dark. Mary was across the street. There was a loud bang and she fell. I looked around and saw a person running away. It was probably Steve. There's no dispute here. There's no genuine dispute about what happened because a judge would never allow witness number 2 to get up and testify because that person just doesn't have enough knowledge about what happened to create a real dispute. So if those are your facts, there's no genuine dispute about what happened because a jury could not possibly believe witness number 2. I think the idea of what a genuine issue is, again, is one of the most complicated intellectual concepts to understand in civil litigation. And these are just very basic examples, but it hopefully gives you a start of how to start, or a beginning of how to start looking at these factual scenarios. What is a material fact? So remember, the summary judgment standard is when there is no genuine dispute of material fact. So we talked about genuine, now we're going to talk about material. Fact is material if it would influence the outcome of the controversy. Another easy way of saying that is, does the fact matter? What is a material fact? So let's start with a legal question. When we talk about genuine facts and when we talk about material facts, we're talking about the bridge between the facts and the law and how they fit together and whether or not they fit together. So when you want to figure out if a fact is material, you need to know what the substantive law is. So let's pretend we have a legal question. Was the defendant driver negligent? Witness 1 gets up and says, the light was red. The defendant's car went through the red light. Witness 2 gets up and says, the light was green, so the defendant had the right of way. In this scenario, the fact finder must decide what color the light was in order to determine whether or not the defendant was negligent. It's a question that must be answered in order to figure out who wins and who loses the case. This example presents a genuine issue of material fact. There is a dispute and it matters to the outcome. Here's another example. Witness number 1 says it was raining when the accident happened. Witness number 2 says it had just stopped raining before the accident happened. This is a closer call. Who cares? Does it matter to the outcome? Well, maybe when you're talking about negligence, how much was it raining? Were the streets slippery? Does it really matter? Maybe it doesn't matter at all, though. So one thing that the lawyer has to do, and the paralegal too, is be thinking about the facts in terms of, do they really matter to the outcome? Because on a close case, somebody who can really understand what's a material fact and what's not a material fact, that can make the difference in a summary judgment motion. So, moving on, at summary judgment, what does a court not do? Court does not weigh facts at summary judgment. The court is not the fact finder, and that is critical when preparing a summary judgment motion. Issues of credibility and bias generally are never going to come into play on summary judgment. Court's job on summary judgment is to determine if the parties disagree about something that matters to the case. There are fancier ways of saying that, and I listed a few from a state case and a federal case. The jury does not try the issues, but decides on summary judgment whether there is a substantial issue to be tried. Anderson v. Liberty Lobby, which is one of the quintessential federal cases discussing summary judgment. That case says at summary judgment stage, the judge's function is not himself to weigh evidence and determine the truth of the matter, but to determine whether there is a genuine issue for trial. So again, the judge looks at the facts, looks at the law, and says, is there a dispute that matters? If this case goes to a trial, is there anything for the jury to do? The statutory authority for summary judgment in Wisconsin is 80208, 80208, and in federal court, it's the Federal Rules of Civil Procedure, Rule 56. One thing that I do, one thing that a lot of lawyers do, or a lot of lawyers should do, before doing a summary judgment, especially if it's not something that you do all the time, is go to the statute and read the statute, or go to the rule and read the rule, because again, summary judgment is very complex, and the statutes and the rules provide a very good roadmap of what you need for a motion, what the standards are. Wisconsin law explains when a summary judgment should be filed. There are timelines involved, what needs to be submitted to the court, what the summary judgment standard is, and details about affidavits. But, and this is critical to any type of motion or filing with any court, you need to look at the judge's scheduling order, local rules, and the judge's standing order. So at the beginning of the case, usually you have a scheduling order where you get on the phone with the judge, or you go to court and decide the timeline or roadmap for your case. That scheduling order is usually going to have a timeline for summary judgment, a due date, and in many scheduling orders, the judge will explain special procedures for summary judgment. They do that in federal court, and some state court judges do it too, and it's very important to go and reference those. Local rules. The federal courts in Wisconsin have local rules, and the state courts, most of them in Wisconsin, have local rules, and they're on the internet. Each court may have different rules about how they want things to be done. In Milwaukee County, everything has to be 2-hole punched before you send it in, even summary judgment briefs, and you'll get a very nasty note. Maybe sometimes you get a nice note reminding you to hole punch your documents. But when filing a summary judgment brief, it's important that all of those rules be followed, and there's a lot of them. So make sure that you consult the rules. As a paralegal, that's one thing that separates a phenomenal paralegal from a paralegal who is just good or mediocre. A phenomenal paralegal like Jackie will say, oh, remember, we're in Milwaukee County. Remember, this has to be hole punched. And, you know, we need to have the margins a certain way. It can't be in this font. Make sure there's page numbers. They're, again, very sometimes minute rules that do make a big difference because some courts will send the brief back. Finally, judges' standing orders. This is not as common in state court, but in federal court, especially in the Eastern District, the judges, in addition to the local rules, have their own set of rules, and those are called standing orders. Those are available on the internet. You can also, in state court or in federal court, call the judge's clerk and say, does this particular judge have any special requirements for summary judgment? Some judges want a courtesy copy, a paper copy, sent to them, and they want it hole punched or stapled or not stapled. Some courts want their exhibits a certain way on a disk or on a thumb drive, and they change. So, and the judge doesn't send out a memo to every lawyer in the state saying, I've changed my rules. So it's very important to consult the rules. A very good paralegal will call a clerk and say, we're filing for summary judgment. We have some visual exhibits. How would the judge like to see them?
I'd also like to add that as you go through the courts, keep a binder or a notepad on how the courts like it, because you will be in that court again. So it's just a reference guide, and it helps.
That's why Jackie's a good paralegal. She's very good at organization. That's something that a lot of attorneys don't have time to do or just don't have the organizational skills to do. But a good paralegal is going to keep track of all of that stuff. And I like to tell everyone that Jackie gets emails from clerks commending her on her filings. So these things really do matter. Under federal law, the Federal Rules of Civil Procedure, they tell you what the summary judgment standard is. They tell you when to file a motion, what must be included in the motion, and they give you guidance on submitting proper evidence. Again, that stuff is critical to review, those basic rules. Every time you go into summary judgment, make sure that you are doing what you're supposed to be doing and filing what you're supposed to be filing. Again, consult your scheduling order, local rules, and standing orders. Before you start, know what court you're in, know who your judge is, and consult your roadmap, which is your scheduling order.
In this, one of the things you want to do is review your complaint. Find your claims, who's relevant in the complaint, with who has relevant information in the complaint. Try to determine what documents would be relevant from the complaint. Talk to the people that you find have relevant information and keep an outline. Also, you want to determine what connection these people have to the relevant information and how to contact these people.
Again, that's something that separates a very good paralegal from everybody else. Jackie comes in several months before summary judgment and says, I think this is a case we're going to file a summary judgment on, but I'm just warning you, we're going to have a lot of documents, we have a lot of witnesses, by the way, this particular defendant is going to Egypt for 3 months, and so we need to make sure that we contact him early. A good paralegal is going to know who's involved, what information they have, what documents we're going to need to worry about on summary judgment, and that'll also help with staff planning. Maybe another attorney or another paralegal or assistant needs to be pulled in to help with the process.
And you want to start determining this at the time the complaint is filed. You're not waiting until 1 month before summary judgment is due and then starting to determine who might be relevant, what documents might be relevant. You want to start keeping a timeline when the case begins.
So summary judgment comes in 3 parts. First, usually it's the defendant filing a motion for summary judgment. Sometimes it's the plaintiff and sometimes it's both, but there's usually one date set where the initial summary judgment motion and brief and affidavits are due. And so your motion and first packet of stuff is due on one date. Depending what court you're in, you'll have either 21 days or 30 days or another predetermined amount of time for a response. And then after the opposing party files a response, then the moving party gets to file a reply, usually 10 days to 2 weeks later. So summary judgment, we have these 3 dates that take place over about 2 months. State versus federal court. Historically, summary judgment was used more in federal court, but it's being used in state court a lot more now. I don't know why that is. It could be that in state court now there's heavy caseloads, there's the expense of litigation, there's more lawyers, I'm not sure. But a lot of state court claims involve claims like negligence, like the car crash case that we talked about before. Usually cases like that, they're going to be filed in state court, usually, not always, but usually. And those are not the type of cases that are summary judgment cases because there's always going to be a disputed fact. Federal cases more often have the type of legal claims that are more prone to summary judgment motions. If you're in federal court, you can be assured that your judge knows the standard for summary judgment and has ruled on a lot of summary judgment motions. If you're in state court, your judge may not have all that much experience with summary judgment. So again, know what court you're in, know who your judge is. If you're dealing with a judge that's not familiar with summary judgment, it's very important to have a section in your brief educating the judge on the standards and going through this stuff. What is a genuine issue of material fact? Because the judge might not know. The procedures are different, the filing procedures, and again, in state court and federal court, this is where you go back to your roadmap and the statutes and the rules. For example, one of the biggest differences in federal court, you have to file something called proposed findings of fact, which is a separate document that lists facts separately. But in state court, generally, that's not a requirement. The main technical differences is that in federal court, there's electronic filing, so everything is uploaded. In state court, some Wisconsin courts are doing that and some are not. But as far as I know, it isn't a requirement. I think it probably will be in a couple of years.
From what I understand, the state courts are preparing to all get electronic filing within the next couple of years. At least that's what I've been told by the clerks.
Dodge County has it. Judge Stork wants everyone to know Dodge County has it.
Judge Stark is on our website singing the praises of e-filing, so hopefully he'll have his wish.
Yes.
So.
Well, e-filing is wonderful because your brief is due at midnight instead of at... That's the main difference. Are you working until midnight or are you scrambling at 4:55, trying to run to the courthouse? So, a recipe for a summary judgment motion. Now we're going to transition our talk a little bit into what you need for a good summary judgment motion. Before we were talking a lot about the more intellectual components, and now we're going to talk about the nuts and bolts. Does anybody have any questions about anything we've talked about so far?
Students, any questions?
Question.
Yes.
Are there situations when a judge will dismiss a case without regard to a summary judgment, just on his or her own?
There are, and that's actually a very complex question. There's judges can sua sponte dismiss things, and sua sponte is, I think it's probably a Latin word that means on your own or by yourself or of their own volition.
Okay.
And I'm sure there are rules when a judge is allowed to do that and when a judge is not allowed to do it. Whether or not a judge is allowed to sua sponte dismiss a case, I don't know that off the top of my head, so I don't want to tell you yes or no. But I do think it's a good question. there is I know in the Wisconsin statutes, if one party files for summary judgment, but the judge decides that it's really the other party the non-moving party who should win, the judge can grant summary judgment to the non-moving party, and that's right in the Wisconsin statutes. That can happen in federal court as well. I don't recall whether or not Rule 56 has that written in there, but I know in the case law that if the judge looks at all the facts and decides that the non-moving party should be granted summary judgment, the judge can do that.
Any other questions, students? I have a couple of follow-up questions. When you talk about the e-filing system, I mean, with some of these summary judgment motions, I imagine your exhibits and your attachments, there are maybe dozens, hundreds of documents conceivably. Is there a limit to the file size that you can upload, or is that something that, you know?
Yes, there is a limit to the file size, but you can split it in parts and then just rename it Part 1, Part 2.
Okay.
It's a pretty simple fix.
Okay. And I think earlier you were talking about standards, you know, the role of the judge in a summary judgment motion, basically essentially deciding, is there a genuine issue of material fact for the jury to decide? And of course, if there is, then the judge shouldn't grant the motion. But do you find yourself having to gently remind judges of what their role is from time to time? Because I can envision a scenario where the judge has reviewed all of the submissions of the parties and is already, because he or she is human and was probably a lawyer themselves for a long period of time, already making kind of a judgment about the strength of one side's case or the other, and then sort of letting that cloud their vision as to how they would rule on the motion?
That's a great question, absolutely. And that's why the standard and understanding the standard for summary judgment is so important, because when I write a brief, I always have a summary judgment standard section in there that recites the standard, even if the judge has presided over 250 summary judgments in the last 12 days. Always put the standard in and then cite cases discussing the standard where the case facts are similar to my case. So if I'm working on a public records case, I find public records cases that involve summary judgment. If I am working on an employment discrimination case, I go and I find, are there particular standards or things that the judge should have in mind when they're looking at employment discrimination cases? The substantive law, and when I say substantive law, the law involved in the complaint, the thing that the plaintiff thinks is unlawful, that's always going to play into your summary judgment. And when I do a brief, each section of my brief is crafted around what the summary judgment standard is, constantly, maybe at least every other page, reminding the judge what the standard is. This fact is material and why. This may be a dispute, but this dispute is not material to the outcome because the plaintiff can't meet all of the elements of his or her claim. So I represent the defendant most of the time, and I'm the one filing for summary judgment. I'm the one for asking the judge to dismiss the plaintiff's case. So I'm constantly telling the judge, there is a dispute of fact here, but it doesn't matter to the case. And when you're trying to get a case dismissed and there is a dispute of fact, that's really one of the only ways that you can get around it. You have to convince the judge that that dispute doesn't matter to the outcome. So you're talking about the facts, you're talking about the summary judgment standard, and you're also talking about the substantive law. And
do you think there's sort of a natural tendency on the part of judges to want to allow litigants to have their day in court, so to speak, and maybe a reluctance to grant summary judgment for that reason and perhaps overlook the standard a little bit, or not so much? It's just entirely dependent upon the facts of a particular case.
Depends whether I win or lose.
Spoken like a true litigator.
Yeah, no, I think that judges, in my limited experience, judges try to do the right thing. They always try to do the right thing. I think judges struggle with their caseloads and the amount of facts and getting the facts straight and getting the law straight. I think judges are probably, a judge doesn't want to be overturned, and a judge doesn't want to have a case proceed to trial where after the plaintiff puts on her evidence, the judge says, oh, I should have granted summary judgment because the parties went through and spent several $100,000 litigating this. And then when the judge sees the facts, they realize, oh, there's no dispute, or oh, it just doesn't matter. Even if everything the plaintiff says is true, she still can't win. I don't think judges want to be in that situation. So, no, I think there are some judges who are more likely to grant summary judgment, and I think those are the federal judges because they're more used to it. But no, I think judges really do try hard to get it right because their calendars and litigation expenses are so out of control that.
Yeah, you'd mentioned one other thing. I'm sorry to keep peppering you with questions, but in your discussion, you said know who your judge is, and I imagine that there are situations, of course, where you've never appeared in front of this judge before. So what strategies could you offer to someone, particularly a newer lawyer or paralegal that's, brand new to Dane County, Milwaukee County, wherever it is the case is? How would you go about finding out more about sort of the culture of that particular courtroom, how the judge runs his or her court, those sorts of things? Is there some strategies that you could share with us? Sure.
When I say know your judge, I don't mean know what your judge would be like if you take him out for a beer. It's more of know if your judge has any standing orders. So look on the internet. A lot of courts have websites now, and judges may have their own page. Google the judge. I always Google a judge I haven't been in front of before. Some judges have blogs, so you can learn about the judges there. Go on Westlaw, type in the judge's name, and you'll find cases that the judges decided before. I always try, if a judge says something favorable in a previous case that's similar to my case, I always try to cite that case. So I'm saying, Judge, look, you've dealt with this before in this case, and this is what you said. So yeah, stalk judges on Westlaw. You can go on Pacer, and for 8 cents a page, you can find out what the judge has been up to, what kind of cases are on the judge's calendar. You can also call the clerk, and I think that's one thing that a paralegal can certainly do. We can say, we're in Douglas County. I didn't even know there was a Douglas County. I don't know where it is. I don't know this judge. Call the clerk and say, hi, I'm unfamiliar with your court. We have a new case. Can you tell me, are there, any procedures that the judge prefers? And usually the clerks will really appreciate that because that makes their job a lot easier. And you make friends with the clerk, and sometimes the clerk will give you helpful information. And if you happen to send something in with a boo-boo and you have a clerk that really likes you, that clerk might call and say, oh, by the way, you messed up this thing, just send me another one really quickly. People will do those favors for you if you are a nice person and establish relationships. So I think that's something, again, somebody who is a phenomenal paralegal will pick up the phone and make those connections.
Thanks.
Another thing that you can do is just use your local resources in the office that you're in. Talk to the secretaries, see if they've worked with an attorney or paralegal who's had a case with that judge before. And like Andy said, it's very important to make friends with the clerks. I know when I call the Western District, one of the clerks knows me by name. Actually, by caller ID. But you can use email in your office too. Lots of people, you'd be surprised, have been before a judge that you've never been before.
Any follow-up questions based upon those questions? Sorry to interrupt.
Jackie, have you seen any mistakes that lawyers or paralegals on the other side have made in terms of contacting the clerk?
Actually, yes. A lot of times they won't. They will follow. A lot of times they'll follow the state court rules, and when they get to the federal, I deal mostly in the federal courts. And when I am with a law firm, or if I have a case with a law firm that generally deals in state courts, they'll follow state rules. And they won't follow the federal rules, and they get a lot of emails back. I can't think of one right off the top of my head. One was a trial where they followed state court rules and they submitted, I can't think of one off the top of my head, but yes, it's very important to just know the rules of the court.
Or not submit proposed findings of fact in federal court. I've seen that
Or not
before.
follow how the court likes the proposed findings of fact. Each court likes it cited a specific way, evidentiary material submitted in a specific way, and not everybody will follow their rules, and the court will mention it.
Even down to stapling documents. You're sending in paper copies of something. Some like staples, some don't want it stapled.
Alternative dispute resolution play any part in like the reference it, or can it be advantageous? Feedback or play in?
Yeah, that's a really interesting question. At the beginning, we talked about, and I can't remember if you were here, but we talked about the anatomy of the lawsuit, how it starts off with a complaint and answer, then we have discovery, summary judgment, trial prep, trial. Alternative dispute resolution or mediation can fit in at any stage, and it's definitely a consideration of when to do it in terms of summary judgment. And that really depends on the merits of the case, the amount of money involved. Preparing a summary judgment motion, depending on the case, can be extremely time-consuming and expensive. We do a lot of civil rights cases. We represent the state, and under those laws, there are fee-shifting statutes. That means if the plaintiff wins, they get their fees. So the plaintiff might win $15,000 and their attorney can get $350,000 in fees. And that's something that obviously we want to avoid. Summary judgment, preparing a summary judgment motion and all of the materials and everything leading up to it, depending on the size, can be anywhere between $10,000 and $60,000 or $70,000 in just expenses of writing the motion and doing the affidavits and doing everything that you need to do to prepare for that. If there's a case that, we feel like, well, we might not win summary judgment, then it might be a good idea for the parties to try to settle it early, before summary judgment. Because if the case proceeds past summary judgment, if the defendant files for summary judgment and the court says, nope, there's a genuine issue of material fact, we're going to trial, that puts the case in a very different position, and that can put the plaintiff on the up. Sometimes that's where you go to ADR or mediation, alternative dispute resolution. Sometimes I'll have cases where I feel like very confident about summary judgment, and the plaintiff will say, well, do you want to discuss settlement? Do you want to go to mediation? Sometimes I'll say, well, I'm going to wait until after summary judgment to do it, because I'm not so concerned. But summary judgment is a huge game changer. especially if the case is going to go forward.
I can tell you from a paralegal standpoint, when the attorneys are talking about settlement and are in mediation, but haven't come to a final decision, I'm still working on affidavits and preparing summary judgment until it's settled and until they come to a resolution. So you don't find yourself at the last minute at midnight trying to file summary judgment.
I'd be there at midnight anyway. That's just me.
My cases usually are too, so.
That, that's a really good point. Again, separating the great paralegals apart, the people who just drive forward. You can't have these parallel tracks going on at the same time if you have a really good paralegal, and that can also put pressure on the other side to settle. If you're ready to go and you're ready to file that summary judgment and you've gotten your affidavits, and you can say to the other side, you can send them the affidavit, this is what I'm filing, this is what you're going to have to face. That, you know, anything that can put some pressure on the other side. Having a paralegal that gathers that stuff and that takes the initiative to go and do it, even if ultimately it's not going to be filed, can make a really big difference.
Terribly sorry, but we got to stop for a second. I lost the feed to the PowerPoint, so apologize for that, throwing a wrench in there.